Welcome to Veranda IAS. In today's Polity Current Affairs session, we are going to learn about plea bargaining. So, what is plea bargaining? So, we will study those plea bargaining. Most of you would have heard this plea bargaining term for the first time. So, this is relatively most unknown concept in India. So, we will study that in today's LU. The learning objective of the session is to discuss the plea bargaining, to examine plea bargaining in news, why we are studying that in news, list the penalties which will be imposed in case of you are accepting plea bargaining, explain the rationale of this scheme, why this plea bargaining will be used. So first, what is plea bargaining? It refers to a accused person accused with a crime bargaining with the prosecution. See, if any person is accused of a crime, there will be two sides. One is prosecution, that is government side, and another one is defense side, that is this person's side. So a person accused with a crime bargaining with the government, bargaining with the prosecution, that is police or government in the sense, for a shorter sentence than what the law provides. For example, let us say there is a case of forgery. For that, a minimum 6 years sentence, once proved, that person will be sentenced to 6 years of imprisonment. I am not saying exact sentence, let us take it for our convenience. 6 years sentence for forgery. A person is arrested, a person is accused. Now the person has two options. One is not to plead guilty and to go against the prosecution, and if he loses the case, he will be imprisoned for 6 years. And the second option is to plead guilty, accepting that yes, I have done this forgery, I am sorry for that, so let us come to a deal. So if that person pleads guilty and if he goes for plea bargaining, the sentence may be reduced. As per law, it is 6 years, but since now here he saves the time of court and prosecution, police, government, everybody, for that sentence, this sentence will be reduced, maybe some 4 years or 3 years. This is what plea bargaining is. So it refers to a person accused with the crime bargaining with the prosecution for a shorter sentence than what the law provides by pleading guilty to a less serious offense. See, this plea bargaining is not applicable to every offense. This is not applicable to some serious offenses like murder, extortion, etc. Okay, this is applicable only to less serious offenses. So it may entail negotiating the charge of sentence magnitude. So the quantum of punishment may be reduced at the end of this bargaining. In India, in our circumstances, the accused may commence the plea bargaining procedure. Only the accused has the liberty to initiate this plea bargaining. Prosecution, on the other hand, unilaterally cannot initiate this plea bargaining. Only the accused have the right to do so. If the accused is not consenting to this plea bargaining, because in plea bargaining there is going to be punishment. Plea bargaining means what? You are accepting that I did this crime. But if the accused person is so confident that we may break this case, we are going to get out of this case, then at that point of time he will not accept to this plea bargaining, right? So in India, only the accused person can initiate this plea bargaining procedure. The accused must petition the court to invoke the advantage of, to take the advantage of this bargaining. The court must determine the applicant's voluntariness. He should not be forced by prosecution, because on the side of prosecution there will be some pressures to close the case earlier, to get the conviction rate earlier. So in some cases prosecution may push for this plea bargaining. So when an accused person is filing for plea bargaining, the court must determine the applicant's voluntariness. He is doing that in his own consent only. He is not forced by police or prosecution during an in-camera hearing in which the opposition party should not be present. Should not be present. The police or prosecution should not be there while this hearing is going on, because if those parties will be there, the accused person will not be truthful to the judges. That is why they are excluded from the hearing. Only there will be judges and the accused person. In that, the judge will certify the voluntariness of that accused person for this plea bargaining. Following that, the court may convene a meeting between the prosecutor, that is, there will be a public prosecutor or additional public prosecutor. He is a lawyer from government's side. Investigating officer, okay, police, investigating officer, and the victim. If there is a crime happened, there must be some victim. If there is a case of forgery, there is a person who committed the crime and there is a person who was affected by that crime, right? So, victim. So, once this plea bargaining petition is accepted, the court will convene the meeting of public prosecutor, that is lawyer of government side, that is public prosecutor, police and victim, to discuss a satisfactory resolution to this matter. Okay, let us settle this matter within ourselves amicably without going through a regular judicial process. The conclusion may include the offender paying compensation and other expenditures to the victim. As I said, this plea bargaining is only applicable to less serious offences. It will not be applicable to serious offences like murder or something. In that case, the case has to be conducted, regular judicial proceedings has to be conducted, a sentence has to be produced only from court. So, there compromise, these kind of settlements will not be allowed. Since these are less serious offences and victim is also consenting to such settlement, victim is also consenting to such satisfactory resolution. He is the one who is getting affected. He is also ready to accept the resolution. Now, what stops them? That is why this plea bargaining. This conclusion will include paying of any compensation amount of the offender to the victim. It may be whatever. Once mutual satisfaction has been established, the public prosecutor has to be satisfied, the police has to be satisfied, and most important of all, the victim has to be satisfied by this resolution. Once mutual satisfaction has been established, the court should formalize this agreement. So far it is informal. It is an agreement reached between these parties. It does not have any legal backing. It is informal. The court has to formalize the agreement by submission of a report signed by all parties and the presiding officer, that is the presiding judge of the court. So, once they sign it and once the presiding judge signs it, it becomes formal, and the sentence or the compensation mentioned in that agreement has to be given to the victim by accused person. So, this is plea bargaining. So, why this plea bargaining in use? Why are we studying this? In July 2020, several members of Tablighi Jamaat from many nations have been released from court trials through plea bargains. In July 2020, there was a conference of Tablighi Jamaat convened in Delhi, in which people from various other countries, various other Islamic countries have attended. Thereby, they have violated their visa restrictions. See, this Tablighi Jamaat conference would not have came to light if there is no corona outbreak. But when there was a heavy corona outbreak in the Union Territory of Delhi, state of Delhi, this Tablighi Jamaat conference is one of the epicenter of disease outbreak. So, these foreign individuals were accused of breaking visa rules by attending a religious meeting in Delhi. So, while granting visa, there will be certain restrictions. They should not go here, go there. They should not attend these kinds of meetings. They should not involve in these kind of activities. So, there will be certain restrictions. They have practically break all those visa restrictions by attending a religious congregation, but they were let go after pleading guilty to the lesser offences and paying the court's penalties. If there is no plea bargaining, they all have to wait for the judicial proceedings to be completed. It will take 2 years or 3 years. Since they are all foreigners, they have to stay 2 years, 3 years in India. They have to complete the judicial formalities. They have to pay the fines, and after only they will be allowed to go to their home countries. But since they plead guilty to their offences, they accepted that they are offences, they are allowed to travel to their countries by paying the court mentioned penalties. This is plea bargaining. After this only this concept of plea bargaining came to light widely throughout India. These instances have heightened awareness of plea bargaining as a strategy for avoiding lengthy trials. So Indian courts have heavy backlog of cases. So these kind of methods will help to reduce such heavy backlogs. Already we have been conducting Lok Adalats, People's Court. This Lok Adalats is also nothing but an informal system where a compromise is reached between two opposing parties, and that compromise will be certified by the judicial officer. That is what Lok Adalat is. Same kind of concept is the plea bargaining. Despite the fact that plea bargaining has been accessible to person accused of criminal offences in India for more than a decade, it is still not often employed. So actually this plea bargaining was not a part of original CRPC. So it was later inserted into the CRPC after the Malimat committee report. Okay, but since then it is not widely accessible because our people does not have any awareness about the availability of plea bargaining in India. So what are the penalties of plea bargaining? Only those who have been charged with an offence that does not carry death penalty. Certain offences carry death penalty. So those offences, the persons convicted, accused of those offences cannot use this plea bargaining. So offences that does not having death penalty, life sentence or a jail term exceeding 7 years are eligible to employ this plea bargaining. So which means less serious offences only. It also applies to private complaints brought before a criminal court. So what is private complaint? See, if there is any murder, that is not a private complaint. The state itself will conduct the case, irrespective of the victim's immediate dependents wish to conduct the case or not. That is not an issue here. If there is any murder, the state itself will conduct the case. The state will act as a prosecution. But there are other kinds of cases in which a private person will approach the court against any private person. This is different from first case. In first case, state versus a private person. In the second case, a private person versus a private person. Mostly these will be civil cases. So this plea bargaining can also be used for this kinds of cases. It is not allowed for offences impacting the country's socio-economic circumstances. Offences which are affecting the country's socio-economic circumstances will not be allowed for offenders. Such offenders will not be allowed to take advantage of this plea bargaining, and also the offenders against women or children under the age of 14. The offenders against women or children under the age of 14 will not be able to take advantage of this plea bargaining. So these are the exemptions. So the sentences, the offences which carry death penalty, the offences which carry life sentence, the offences which carry jail term exceeding 7 years, the offences which is impacting the socio-economic circumstances of the country, the offences against women or children under age of 14. So these kinds of offences are exempted from using plea bargaining. So what is the rationale of this scheme? What is the rationale of this plea bargaining? It puts an end to the ambiguity surrounding the result of criminal prosecutions. A layman will not be aware of legal procedures and prosecution procedures. So this will aid to bypass that procedure, to avoid that tricky, lengthy procedures, reduce litigation expenses and alleviate anxiety among the parties. It will be a stress relief. So they does not have to wait for 5 years, 10 years, 15 years for the complaint to get over. They can settle the issues between them with the presence of police and public prosecution amicably. Conviction rates are also affected. See, in India, conviction rates are always low, be it a civil case or criminal case. There are issues from prosecution side, there are issues from judicial side, there are issues from police side. All this collectively affects the conviction rate of any state. So this will help to reduce those backlogs. It will reduce to increase the conviction rates, assist criminals in reclaiming their lives. They does not have to wait for 5-year, 10-year long as a under trial. They can face their punishment immediately. They can finish that and they can go back to their normal lives. So these are the rationales of this scheme. So students, in today's LU, we have learnt about plea bargaining and why this plea bargaining is in news and what are the penalties, what are the crimes that are exempted from this plea bargaining and what is the rationale of this plea bargaining scheme. So that is all for today's LU. We will meet in another polity current affairs LU. Until then, thank you very much.